I am admitting the law clerks in, starting their recording, and letting IT know we can start. I am asking the attorneys to start their videos. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-3080, United States of America versus Johnny Carl Lainez, appellants. Mr. McIntosh for the appellant, Mr. McGovern for the appellate.
Good morning, Mr. McIntosh.
Good morning, Your Honor. I will start my argument. May it please the court. Appellant has presented 4 issues for this court. In order to preserve time, I'd like to start with arguments 1, which concerns the application of 4B1.5 to enhance Mr. Lainez's sentence, and argument 4, which whether or not the sentence was unreasonable because of guideline calculation errors. If time permits, Your Honor, I will discuss arguments 2 and 3. Now, this case, when we talk about whether there was error in applying 4B1.5 to the sentence and whether or not the sentence was reasonable, there are 4 questions which, when reviewed, will provide an answer to these questions. The first question is did trial counsel waive appellant's right to assert the doctrine of U.S. v. Wickerlink that the prior conviction must be compared to the instance offense before the 4B1.5 application? 2, whether the case presents grounds for plain error review by this court. 3, what is the government's burden to produce sufficient reliable evidence when it seeks to employ 4B1.5? And finally, whether there was error in the application of 4B1.5. The first thing I want to talk about is trial counsel's possible waiver. That's the argument the government makes. There was no waiver. As stated in the appellant's reply brief, the plea agreement allowed him to contest the criminal history in the plea. The judge in the guilty plea colloquy noted that he had the right to challenge the criminal history.
Is that just before the district court?
The district court, yes, the district court, Your Honor.
But he didn't preserve the right to contest that on appeal.
Well, what I am saying is that the plea agreement allowed the appellant to contest the criminal history. And in addition to the plea agreement, you have that noted by the trial judge in the guilty plea that he had a right to contest the criminal history. Then we go on before sentencing. Defense counsel sentencing memorandum specifically stated that the 4B1.5 application made it greater than necessary to achieve the goals of sentencing per the Sentencing Reform Act. If you didn't have this 2002 prior conviction, he would ask for a downward variance, okay? Then in the sentencing memorandum, counsel went on to distinguish the instant crime, the 1591 violation, as a computer-related communication. He said it was different from the prior conviction for statutory rape. And I think that's plain on its face. At the sentencing hearing, counsel again alerted the trial court to the fact that the instant offense was different than the prior sex conviction. And at sentencing, again, he asked
Did
for,
trial counsel argue that it was different so that it could not be a predicate offense for the sentencing enhancement?
no, he did not. No, he did
Should
not.
counsel have done that? You haven't argued here that counsel should have done that. I'm curious as to why.
Well, I do not know what was in the minds of trial counsel. I agree with Your Honor that he did not argue the Wicker Link basis.
I'm asking whether you think he should have. That it was not a proper predicate offense because the elements of carnal knowledge under Virginia law are not the same. In fact, are broader than the elements for the federal offense.
Looking at the law, yes, he should have. Yes.
Okay. But you didn't raise any ineffective assistance to counsel argument on that in front.
I did not raise that, Your Honor, because in terms of looking at the facts of the case, I don't think the government has met its burden anyway.
That's a separate question of whether counsel, when someone's trying to apply an enhancement based on a prior conviction, should check and see whether that prior conviction is a proper predicate for the enhancement. And had they done so here, it would not have been, at least under a categorical analysis.
You are correct, Your Honor. You are
So
correct.
why was that? I'm curious then again, as to, since you're agreeing with this, why you didn't raise ineffective assistance of counsel, because had they made that argument, they could have prevented the predicate offense from even counting, perhaps.
I did not raise it because we have on the record the right of him to right of the defendant there to raise these issues, and we do have trial counsel alerting the court to the fact that the sentences were different. Now, the court is correct that he should have specifically argued the Wicker Link doctrine. He did not do that, but he did alert the court to the differences in the statutes, and that goes to the Wicker Link doctrine. Under Wicker Link, the court advises that when you're trying to assess whether or not trial counsel waived, that the objection must fully apprise the court of the grounds for, that trial counsel should fully apprise the court of all the grounds so that the court can take it into consideration. If you take a narrow view of what occurred in the lower court, you could say, yes, that's ineffective assistance of counsel. If you take a more reasonable view, because he did alert the court to the difference in the statutes, I would say that's not ineffective assistance of counsel. It just depends upon the way that it is interpreted, Your Honor. If this court finds that trial counsel, by not fully, fleshing out the Wicker Link doctrine, was ineffective.
Well, you haven't raised that issue, so I don't know how we could. You haven't presented that issue to us, so I don't know how you think we could reach out and decide it. That's what I'm asking you, is why that issue isn't here, since you've noted in your brief here that the attorney pointed out some distinctions between the two offenses, but missed the legally relevant argument altogether and didn't present it to the court. And that is that it doesn't statutorily qualify as a predicate offense, which seems a rather significant omission.
I see exactly what you're saying. And the only way I can honestly respond to Your Honor, as I said, it depends upon how you interpret what he did. If it's a strict construction.
But you told me he didn't raise it. There's no interpretation there. You don't see it raised. We don't see it raised. I don't know what interpretation that requires.
Okay, well, I understand, Your Honor. I'm just trying to make the point that in a bare bones way, he raised it. He didn't fully flesh it out. Okay, but
He
he
didn't object to the guidelines calculation. I don't know how we can say he
Well,
raised it.
well,
Unless I'm misremembering. I don't recall. I recall them agreeing repeatedly to the guidelines calculation, unless you tell me I'm mistaken.
as a practical matter, Your Honor, I guess is correct, but that he did not object in a sentencing memorandum. But what I am just trying to say, in his sentencing memorandum, he pointed out the differences, and in the guilty plea and in the sentencing hearing, he pointed out the differences. And that may be sufficient to alert the court to the argument that we're making here. If not, then this court has an opportunity to exercise its discretion and do a plain error analysis of what occurred in the lower court. And for plain error, as the court well knows, you need error. Error was clear and obvious. It affected substantial rights, and it may affect the integrity, fairness, and reputation of the judicial system. Here, he would have gotten 188 months as opposed to the 235 he got. I think that's about a 4 or 5 year difference. So that did affect his substantial rights. And
Mr. McIntosh, you're over time. Unless either of my colleagues have any further questions, we'll hear from the government.
Okay.
Not from me.
Okay.
May it please the court, Michael McGovern on behalf of Appellee, the United States. Appellant's sentencing error claims fall squarely within the scope of the appeal waiver contained in the parties' negotiated plea agreement, and therefore, this court should dismiss appellant's appeal. In the negotiated plea agreement, appellant waived his right to appeal his sentence under unambiguous and specific language that did not allow him to appeal either his sentence or the manner in which that sentence was determined, subject to only 2 specific exceptions, neither of which are applicable here. He was permitted to appeal his sentence if it was above the statutory minimum, or he was permitted to appeal his sentence if it was above the statutory guidelines range determined by the court. Because neither of those were present here, the unambiguous language of the appeal waiver within the plea hearing should be upheld, and this court should dismiss his claims as it did under both Adams and Lee.
Mr. McGovern, do you think trial counsel was ineffective?
Your Honor, ineffectiveness has not been presented here, and there are important legal issues that would have to be explored prior to a determination that legal counsel was ineffective. For purposes of argument, appellant has assumed that Wickerink's categorical approach applies. It's unclear based on this record if one could even analyze this case under Wickerink based on the present record, because there is no indication of what statute he was convicted of in Virginia in the record. And
Well, there absolutely is. No, that's not. It's actually in your supplemental appendix, page 14. Conviction for carnal knowledge of a child 13 to 15 years of age, which is very easy to find right in the Virginia statutes. And the definition is much broader than the federal definition. If nobody knows what he's convicted of, on what basis would a prosecutor assume that it's a predicate offense?
The predicate offense was described within the pre-sentence report, and in that description, the description contained facts which do satisfy a federal crime.
No, but that's not how, that's not how it works. That's not how it works. We have to look at the 2 statutes.
If one applies the categorical approach, but it's not a legal conclusion, nor has every circuit been on the same page that necessarily a categorical approach must apply.
You said that nobody knew what, excuse me, you said nobody knew what the offense was. Would not it be incumbent upon the government to determine what he was actually convicted of rather than sort of a loosey-goosey description? And then the government would have to take a position on whether, or apply its already established position on whether the categorical analysis applies before the government would even argue for this. Isn't that, I mean, the government doesn't just sort of go, someone said something and that's good enough for a predicate offense, do they?
Well, Your Honor, respectfully, that's if the categorical approach applies here, which
What is
that
the
has
government's-
not been determined by this court, and
Correct,
it hasn't been determined
correct.
by multiple other circuits. What I will note is this
Sorry,
issue.
excuse me, I'm sorry, just slow down for a second, please. I have a basic question. What is the United States government's position on whether the categorical approach applies under this sentencing enhancement?
So, Your Honor, the government hasn't taken a position in this court, and it's not
What is it
necessary
taken
to
in all
do
the other
so.
circuits? What is it taken in all the other circuits?
Your Honor, in the Third Circuit, it has sought for a fact-based approach in the case of Dahl. And in fact, there have been circuits that have applied a fact-based approach. Even the Eighth Circuit,
Which circuits have applied? I know the 11th Circuit did sort of a half and half.
Correct, Your Honor. I was referring to
Any
the
other-
Eighth Circuit.
Okay. Any other
Also,
circuits?
the Eighth Circuit, if you read the Lockwood decision, in fact, the approach that it applies, and I'll note that appellant does cite to Jeffries, which relies upon Lockwood, so it is presented here. And I'm going outside of the legal arguments that are within this actual case, as none of this was presented.
I
appellant's.
fully understand that. And I'm just trying to understand, because you're the one who said the government applied it even though we didn't know what the conviction was for, which was what obviously raised an important question in my mind. And I'm sorry, can you say again, did you say the Eighth Circuit didn't apply a categorical approach?
The Eighth Circuit in Lockwood actually began with a typical categorical approach, but where a statute criminalizes conduct that is broader than, is inclusive of the federal offense, but is broader, it then looks to the facts, and it didn't apply a divisibility analysis. And so therefore it actually applied a broader than categorical approach. It's not a strict categorical approach or a strict modified categorical approach if you read the way in which Lockwood presents it. That's similar to the way in which the 11th Circuit presented it. And here, the United States, the information that it relied upon was—
Back up again then? Sorry, oh no, go ahead, finish that sentence. I'm sorry, go ahead.
Was within the pre-sentence report, which was that there was a conviction for carnal knowledge of a child, and that child was 13 years old, that at the time of the conviction, the defendant was 30 years old, and he had sexual intercourse. Those facts were available as to what the substance of the conviction was.
Well, it wasn't just
It's
facts.
also important—
It wasn't just facts, right? The carnal knowledge of a child is in quotation marks. That's the statement, that, some of the name of the offense under Virginia law. I just wanted to follow up on, and maybe I just misunderstood you when you first spoke. I heard you say that the government didn't know exactly what the record didn't show what he was actually convicted of, but they applied it based on the facts. But the pre-sentence report identifies the, not the pre-sentence report, the statement of facts, statement of offense, identifies it by name, because it would be worrisome to me if the federal government didn't even bother to find out what statute someone was convicted of and then applied it.
But it's also important to note here that this was a negotiated plea agreement. So not only did the government agree that this applied, but appellant agreed that it applied. And in exchange for that agreement, appellant received very important concessions from the government.
I need to back up again. I'm not talking about that part of it. I'm just talking about where the government's starting point was. And the fact that someone didn't challenge it as a separate, or agree to it as a separate question. Is it the government's practice just to take a factual description like that, or is it the government's practice to identify, if at all possible, and it was quite possible here, to identify what they were actually convicted of, and then it can apply the U.S. government's position, whatever it is, on categorical or not, before doing it? I assume the government is going through some standardized legal process before it claims an enhancement, rather than just claiming it willy-nilly and waiting to see if the other side objects.
Your Honor, I am not currently have knowledge of what precisely this particular attorney did or what precisely the general conduct is. Because none of those issues were raised in this appeal.
Okay,
those
factual.
So
what it is not, then I should not take, as I understood your first statement to be, that they actually didn't know and it didn't matter to the government.
I
what he was
apologize if
actually
I
convicted
ever
of.
said that it didn't matter to the government. What I said was that there is no citation currently in this record. There is no citation to the legal provision under which the individual was convicted in Virginia. And on a plain error review, which we're on here, as Your Honor noted, appellant did not object in the trial court to the application of this provision. In fact, we believe he waived because he actively negotiated for its application. And then at every step of the way, both in the plea hearing, in the sentencing hearing, and his own sentencing memorandum, he advocated for its application.
If it did apply, if a categorical approach were applied, though, it would not have been a proper predicate here, correct? The carnal knowledge statute in Virginia, because it's broader than the federal one.
If a strict categorical approach applied,
Well, I don't know that we've used the adjective strict in front of it. We just call it the categorical approach, as opposed to the 11th Circuit modification, if the or a modified categorical or anything else. So if the categorical approach applies, as the Supreme Court has it under other statutes with respect to sex offenses like these, then it wouldn't have been eligible as a predicate because
Your
it's
Honor,
broad.
that analysis wasn't ever done in this case.
I'm just asking you a legal question.
Right. So because it hasn't yet been.
Excuse me. I'm sorry. One at a time. We'll work a little better. Sorry. And so I said, that's why I asked my question. If the categorical approach applies, it seems to me pretty straightforward.
So, Your Honor, the government would have to do that analysis, would have to look at those elements, and would have to compare them side by side. And in this case, that wasn't done in this particular case because this would be on plain error review if it's not in fact waived. And
well, it wasn't done on the record or anything, but I'm hoping that what you've told me is that the government would have applied whatever its own approach to this is to the statutes before it claimed an enhancement.
Well, and again, Your Honor, the question as to whether or not the categorical approach does apply here doesn't need to be answered either by this court or we believed on appeal, given that the appeal is defeated by the fact that there is waiver and there is plain error. And although counsel has today stated that he believes that it would not meet the categorical approach, he has never before this court conducted that analysis for the court or presented that. And it is his burden on plain error to show that prejudice would attach. And he hasn't been able to do that because he hasn't come in to compare those elements to show that the categorical approach does not apply.
Okay. Any further questions?
Nope.
Not for me.
Thank you. Thank you. Mr. McIntosh, you are out of time, but if you have any response to Mr. McGovern's argument, you can take 1 minute.
You need to unmute.
Can you hear me?
Yes.
Now we can.
Okay, all right. As to what was in the plea agreement, the government drafted that contract, and it's just fundamental that it has to be, when interpreting, it has to be construed against the government. Also, statutorily, this is a criminal case, so when you look at the parties, if the defendant is facing criminal time, then it should be construed in favor of the defendant. Now, we didn't talk at all about burden. The government, not the defendant, has the burden of producing evidence for this enhancement. They did not do that. They cannot rely on a pre-sentence investigation report if their disputed facts is contradictory, or implausible, inconsistent with the evidence at trial. In the pre-sentence report,
Their statement of offense defines a crime that define factually a crime that fits within the federal statute. Why didn't that meet their burden of proof?
Your Honor, that's a negative. That is not the appellant's burden of proof. It is the government's burden of proof. I didn't have to prove that. That's asking me to prove a negative. It's the government's burden. That's at Price. US v. Price says that. the probation report lists prior crimes as statutory rape, while the trial court and the government supplement listed as carnal knowledge. Who knows? The government should have done that analysis because that's its burden.
Okay. Mr. McIntosh, thank you. You were appointed by the court to represent the appellant, and we appreciate your assistance. Thank you.
Thank you, Your Honor.
Case number 20-7117, Theodore Wesby et al., appellants, Antoinette Colbert as personal representative of the estate of Ethelbert D. Lewis versus District of Columbia et al. Mr. Economos for the appellants, Ms. Anderson for the District of Columbia appellees.
Good morning. My name is Lucia Goin, and I'd just like to introduce the student arguing this case on behalf of plaintiff appellants. I'm a law fellow and supervising attorney in Georgetown's Civil Rights Clinic, who is counsel to plaintiffs in this case. And Mr. Orlando Economos is a third-year law student in the clinic who will be arguing the case under Circuit Rule 46G. So unless the court has any questions about that, I will turn it over to Mr. Economos.
Thank you. Good morning.
Good morning, Your Honor. Thank you. And may it please the court, my name is Orlando Economos, and I'm here on behalf of appellants. Restitution is a remedy that is granted by the court only after a careful evaluation of the equities of the parties before it. Here, the district court granted restitution to appellees without balancing the equities. That was an error of law. The court created a categorical rule that a legally unenforceable judgment always warrants restitution. It held in the opening paragraph of its opinion, plaintiffs must pay restitution to defendants because the legal process has coerced from defendants money not legally owed. And I'm looking at 401 in the joint appendix there, Your Honor. But that is not what the law of restitution requires. By definition, it can only be awarded after a careful evaluation of the parties before the court. The Supreme Court held as much in Atlantic Coast, where it stated it, quote, will not order restitution where the justice of the case does not call for it. And that's the equitable analysis that's required, Your Honor, and that's what we're looking for today. Regardless of why the underlying judgment was vacated or reversed, Atlantic Coast stated that all suits for restitution are subject to an equitable analysis, including those made on a reversal of judgment. They further stated there that the claim for restitution yields to the impact of these converging equities with all their cumulative power. And
Can I
this
pick
court,
you up and ask? It's a little hard for me. Some parts of the district court opinion sound like what you said, where it found like once it found an invalid judgment, a payment had been made under a substantively invalidated judgment. That was unjust enrichment and there had to be payment. So that kind of sounds like that on the page you cited, and it kind of sounds like that on page 407. But then on 405, you know, the district talks about it's an equitable remedy. You always look at the equitable circumstances. And so how do I know which page? If at times the district court seems to be acknowledging the application of equitable circumstances, and at other times doesn't, how am I supposed to know that there's a legal error here, as you call it, as opposed to he just didn't quite explain it?
Your Honor, yes, both at 401 and at 407, the court talks about how it is compelled to order restitution here because of the nature of the underlying judgment. And although the court discusses the requirement of, considering the equitable circumstances, if one takes a look at the opinion in its entirety, effectively what it's doing, there are only two sentences that recite a mere two of plaintiff's assertions without any further analysis or evaluation.
Well, but I think if you look at 406, what he says is in this context, in invalidated judgment, personal circumstances play a diminished role. It doesn't say no role, just play a diminished role. That's quoting the restatement. And he recognized the ability for affirmative defenses. So before he found unjustness, he recognized a role. And then after finding unjustness, he allowed sort of equitably based affirmative defenses as well, but there wasn't a relevant one.
Your Honor, 2 points in response. And first, the court in the very next section says that regardless of plaintiff's personal circumstances, a payment and satisfaction of a legally groundless judgment warrants restitution. And when it comes to actually discussing the assertions raised by plaintiffs, again, there is no evidence that the court actually evaluated the weight of those arguments, the weight that they played in the order for restitution. And second, Your Honor, the apologies. We see nowhere, for example, a discussion of the public interest in the opinion. We see nowhere, Your Honor, a discussion of the high levels of debt, anywhere from $5,000 to $330,000 that each plaintiff retains, the very few assets, if any, that they have. And all of these considerations would have played a role in the analysis had the district court taken them into account. What the district court did was recognize that generally equity requires consideration of these factors, but then found that in this context, in the context of substantively reverse judgment, that there was no need to do so, that in such a context, restitution is compelled because of the nature of the underlying judgment. But again, that's not what the law of restitution requires. And this court has incorporated the principles from Atlantic Coast in Williams, where it stated that it has the authority to deny restitution altogether if compelling equitable circumstances so dictate. That there, it could not, apologies, Judge Tatel.
No, you go ahead. You finish your sentence. Sorry.
Simply that there, the court could not, quote, ignore the realities of Metro Transit's financial experience during the years in question, and then took several pages of its opinion to discuss precisely those financial realities. Here, we see no such discussion.
So I just have 2 quick questions for you. Number one is it your position that none of your clients should have to pay restitution?
Your Honor, it is our position that this court should vacate and remand so that the district court can take proper consideration of all of the equitable factors before it in making that determination in the first instance. I would be hard put to do that balancing, given that the factual record was not as developed as it could have been had the district court taken consideration of those very equitable factors. And again, I would turn
but
you
to— I hear you acknowledging then that if the district court under your view, were to have properly balanced the equities, that some of your clients might actually have to pay, right? Because they do have some financial resources, correct?
Indeed, some clients do have some financial resources, but looking to each individual plaintiff, whether some have some small amount of positive net income on a monthly basis, those plaintiffs will also have large amounts of debt. Plaintiffs who don't have.
Second question is, and I just, maybe you can help me understand this. Let's assume we were to affirm this. What then happens? The District of Columbia then has to collect its judgment, right? Mm-hmm. And I assume with a lot of your clients, they'd have to go to court, because according to the records I see here, some of them have nothing, mm-hmm. Right? Yes. So how would that, would their financial condition be taken into account at that point?
Your Honor, yes and no. It would be taken into account in terms of the fact that it would be very difficult for the district to collect, simply because these plaintiffs lack the assets to pay the judgment. But even if they were unable to pay it, the fact that they've been ordered to do so would certainly impact their credit. What few assets, if any, they retain would be depleted. At bottom, to order restitution here would be to further impoverish these plaintiffs.
I understand your point. Thank you.
Thank you.
Yeah.
I would turn you then, if I could, Your Honors, to the First Circuit's analysis in Texaco, which we find particularly instructive. Texaco versus Department of Consumer Affairs The district court there considered a motion for restitution and considered the equity of the parties with painstaking care, discussing 5 distinct equitable factors over 3 pages of its opinion before.
Why do you need a First Circuit decision given Thompson? Doesn't Thompson do everything you want?
Sorry, once again, Your Honor.
Doesn't Thompson provide the support you need for your argument about the district court's obligation to consider all of the equities?
Indeed, Your Honor. Thompson does everything we needed to, and specifically discuss plaintiff's ability to make.
Yeah. Okay.
And the reason I cite to Texaco is merely because we find it illustrative on the point, and specifically with regards to the circuit court's capacity to review the district court's decision. The district court's point-by-point analysis was then taken point by point by the circuit court. If you were to attempt to do such a review here, it would be very difficult because the district court did not make the findings, did not say specifically which equities it was considering. And to go to Judge Millett's question earlier regarding the affirmative defenses that plaintiffs raised, quite frankly, the district court did not consider one of the affirmative defenses that plaintiffs raised, that of undue hardship to the parties. And so, again, I would stress that.
Can I clarify too, the district court said that you had conceded that you didn't have a change of circumstances, that their financial circumstances didn't change, and he treated that as a concession of the change of position defense. And I wanted to ask whether that's what you meant by that statement when you said they didn't change their financial circumstances based on these payments. They were already extremely poor and they remained extremely poor. Did you mean to concede the change of position defense, or did you have a different angle or theory of the change of position defense?
No, Your Honor. We did concede the change in position defense quite simply because plaintiffs did not have the financial resources to change their position. They had to spend the money that they received on basic life necessities, on debt service. They were not able to make the sort of large investments that would have put them in a position of having, or rather, to have changed their position in reliance on the judgment. I see that I'm well over my time, Your Honors. If there's nothing else, I will return on rebuttal.
All right. Thank you very much. We'll go ahead and hear from the district, and I'll give you a minute or two for rebuttal.
Good morning, Your Honor.
Ms. Anderson?
Thank you, Your Honor. Good morning, and may it please the court. Stacey Anderson on behalf of the District of Columbia Appellees. Your Honors, the court should affirm in this case because there was no error of law or abuse of discretion here. The district court did not impose a categorical requirement that restitution be ordered.
Ms. Anderson, what do you do? Let's just go right to the heart of the matter here. Mr. Economist cited, he quoted this sentence. This comes at the end of the analysis. So it's a district court's concluding argument. He says, quote, regardless of the party's personal circumstances, a payment in satisfaction of a legally groundless judgment unjustly enriches the recipient, and thus warrants restitution. And he cites the Second Circuit case, and he emphasizes the word compelled to rule that restitution is required. I mean, that looks like the district court concluded here that, as he said, that in a situation like this, regardless of the plaintiff's financial condition, he had no choice but to require restitution.
Right, Your Honor. I don't read the opinion that way. I think the district court's concluded
about this sentence, but I know you don't read them. You're totally right. There are places where it suggests that, maybe the district court did at one point consider the plaintiff's condition, and in fact, he allowed them to submit data about it. But this is the last sentence of his analysis. This sentence, regardless of their condition, he says.
Correct, Your Honor. And my point on that is that I think the district court felt compelled on the facts of this case to reach that conclusion, because after weighing the equities, it concluded the district's right to recover here was overwhelming. If we begin with the premise.
Excuse me, I'm sorry, but it says regardless of the party's personal circumstances. That's the way the sentence starts.
Correct. Correct, Your Honor.
It's not suggesting there that, I've considered their personal circumstances. He says, regardless of it, he's compelled to order restitution.
Correct, Your Honor. And again, I think if we go back and we start with the basic concept of equity in this context, equity is focused on the fairness in the relationship between the parties. And in looking at the relationship between the parties, both the restatement and decisional law focuses on the legal obligations and responsibilities between the parties. As between the two parties, would it be equitable to allow the plaintiffs to retain the monies that the district paid under legal compulsion from an order that was subsequently vacated? And the district court correctly recognized that in this context, personal circumstances do play a diminished role. And the district questions whether or not, again, what is the definition of personal circumstances? I think plaintiffs offer a broad construct of that concept here to go outside the relationship of the parties, to consider other matters that don't bear on the legal rights and responsibilities as between the parties. And I think the district court.
I'm sorry, just were you done? I didn't mean to interrupt.
No,
Go right ahead, Ron.
Okay. I'm rather confused, I will say, because the district court said for them, the fact that they were spending money on ordinary living expenses isn't relevant to the equitable analysis. But in the case that Judge Tatel referred to earlier, Thompson versus Washington, the District of Columbia itself, your client, persuaded this court that it would be unjust and inappropriate to order restitution by reason, quote, by reason of the financial difficulties currently being experienced, quote, by the government. And that the government was facing a progressively worsening financial situation of its own accord, not caused by these parties, and nothing about their relationship between them, and that their income of this agency was insufficient to meet needs. And that sounds, those equitable factors that the District of Columbia said apply when it's a District of Columbia client that's arguing against restitution were properly considered. But here you argued and the district court agreed that those exact same types of financial circumstances, dire financial circumstances, income less than outgo, are legally irrelevant. Can you please tell me how both can be true?
Sure, Your Honor. I'd be happy to address that, Your Honor. First of all, I see Thompson as a very different case than the one presented here, because there was an underlying legal liability between the parties. There was a right to a rent increase. The rent increase decision was overturned on procedural grounds, so there was still a claim of liability between the parties. And the restatement recognizes in that context where there is an underlying claim of liability between the parties based on their transactional history, that other equitable
nature of that issue. Excuse me, the nature of that, I'm getting an echo, I think. We said there that the burden on DC was to show by compelling equitable considerations, compelling, not just a basic ordinary balancing. We applied a compelling equitable considerations test, which sounds to me a lot like the type of requirement that's applied when you're dealing with an invalid judgment, a substantively invalid judgment here.
I disagree, Your Honor. Where you have a substantively invalid judgment with no underlying legal liability on the part of the district here, we do have a right to restitution, an overwhelming right to restitution based on the equities, just simply from that fact, the need to correct.
Was the district agency's increased charge of rents found to be substantively invalid?
I don't believe so in Thompson. It was a procedural error. There was a right to a rent increase. The question was how much. That's the way I read Thompson. And here we don't have
a procedural error. That sounds like a substantive error.
Well,
you were charging more than you were legally entitled to charge. It wasn't like you could go back and have a new hearing. You just forgot to introduce some evidence or something. It was legally invalid what you charged them. Full stop.
But we were entitled to charge something. The amount we charged was incorrect. Granted, but we had a right to collect something. Here, plaintiffs have no right to collect anything.
And was the restitution there for the full rent or the difference? the illegal difference?
I think it ultimately, I don't know the ultimate outcome on remand, Your Honor, but I do believe that restitution was not ordered for a variety of reasons.
For
But
even that illegal difference, the substantively illegal difference.
well, again, I'm not going to concede that there was a substantively illegal difference. It was reversed on the amount charged. I don't know that there was ultimately a determination as to what would have been the appropriate amount given the disposition.
No,
of the
but there would have
case.
been, if that amount, I'm sorry, I just want to make sure I'm following your argument. So, if a court holds that amount X is legally invalid, you can't charge that. Now, you can apply something, minus X, lower than X. But whatever that delta is between minus X and X is substantively legally invalid.
Correct, Your Honor.
In the same way that their judgment was legally invalid.
Not in the same way, Your Honor. I would disagree with that. The difference here is there is no delta. The delta here is zero. They have no legal entitlement to keep any part of the judgment in this case.
No, but as between the X and the minus X, that there's also no legal right whatsoever for the District of Columbia to have collected. No right, zero.
But they had a right to something at the end of the day, Your Honor.
That doesn't. If they're not trying to get everything, if they're only trying to get the delta, there's zero right.
Can I just interrupt? Ms. Anderson, your answers to Judge Millett are confusing to me. I thought your position was that the district court did have to take it under equitable standards of the plaintiff's financial situation, and that he did.
Your Honor, he did.
Am I misunderstanding your argument? It sounds to me like you're arguing in response to Judge Millett's question that he had no legal obligation to do it. In fact, he couldn't.
No, Your Honor.
What is the district's position?
Your Honor, the district's position is, in the mine run of cases where a judgment is vacated.
Don't tell me about the mine run of cases. Just answer the question about, in a case like this, where the reversal of the judgment was substantive. Does the district court have an obligation to consider equity, including the financial condition of the plaintiffs, or does he not? That's all.
Your Honor.
That's all I want to know.
Correct, Your Honor. Plaintiffs have not.
Correct?
Your Honor, plaintiffs have not. I'm sorry. I meant to say, I understand your question, Your Honor. Plaintiffs have not cited any authority for the proposition that their inability to repay the restitution is a consideration here. Now,
okay, that's not, Ms. Anderson, please answer my question. When I read you this sentence at the end of his opinion, where the court said, regardless of their circumstances, he's compelled. Your response to me was, well, he did consider the equities. That, right? If you look at the whole opinion. So I would like you to just state for the court, does the district believe that if you read the district court's opinion here, he considered their financial situation and balanced it, and after balancing it, considered that they had to pay restitution? Is that your view, or is your view that the district court was required by law not to consider their financial condition? That is, that he's, quote, compelled, as he says at the end.
Your Honor, I
read
the district court's use of the word compelled at the end of its decision to mean the equities were so overwhelmingly in favor of the district in this context that the court was compelled to grant restitution. And Your Honor, if I could just step back.
Was that the first or the second of what Judge Tatel said? I'm still not clear. He gave you two versions of how the law works. Do you agree with the first version or the second version?
Your Honor, I believe the district court did consider the arguments and the evidence that plaintiffs presented in this case, properly afforded it a diminished role given the overwhelming equities here that go with the vacation of a court order.
What's the difference between diminished role and no role?
I think
in a case where the reversal was on substantive,
right. Again, I think it would be very, very difficult to overcome the equities in this case based on the inability to pay, given how substantial they are. And if I could just make one point with respect to that.
How could the court have considered, let's assume you're right, that the court did, that you can read this as suggesting that the court did consider the equities. the district court drew no distinction between any of the individual plaintiffs. Some of them have $1,000 or more of monthly income. Some are homeless, destitute. There's no indication in the court's decision that he considered those, and that's my understanding of what equity is. I mean, right? So,
Your Honor, again, plaintiffs painted their clients as being all similarly situated, and I think the district took them at their word and considered them in that regard.
Well, that's not what Mr. Economist just told us.
Oh, I suggest the briefing indicates otherwise in the district court.
Okay.
And here as well.
Unless you're well over time, unless either of my colleagues have any more questions, either, do you?
I'm still
Okay.
not clear. You
Yeah.
go, please go ahead, Judge.
No,
Millett.
You go ahead.
Go ahead, Judge Walker. Good luck. Ask it again. See if you answer.
I mean, because Ms. Anderson, there's a scenario where the district court considered the plaintiff's financial situations, decided that that was a factor, but it wasn't a strong enough factor to overcome other equitable factors, and then reached the conclusion that it did. Do you believe that's what the district court did?
Yes, Your Honor, I believe that is what the district court did.
And then one more question. Do you believe that's what the district court should have done?
Your Honor, I believe that the district court plaintiffs have not, I think whether the district court should have or not, it did here. And I think that is clear from the record. And I just want to make, if I could
That's
make
a
one,
no,
I think
you're deciding not to answer the question, which is okay. If that's your answer, that's your answer.
but Your Honor, can I just, if I could just make one, I think one significant point here.
That's it. Okay.
Thank you, Your Honor. When we look at the district's motion to stay the court's mandate in this case, plaintiffs argued there would be no irreparable harm here. And rightly so, because this court has routinely held an award of monetary relief does not give rise to irreparable harm, because if you succeed in your litigation, you get your money back. So we begin with that premise. The equities strongly favor almost automatic return where there's no underlying legal liability between the parties. And I think the district court correctly recognized it. It heard plaintiffs' arguments regarding affirmative defenses as well as the financial situation of the plaintiffs, but at the end of the day concluded that overwhelming need to correct the coercive effect of that invalid legal judgment outweighed the equities. Indeed, it's the district's position here that it would have been an abuse of discretion had the district court ruled otherwise in this case.
All right. Okay.
Given
Ms.
these strong.
Ms. Anderson, thank you very much. We have your argument.
Thank you, Your Honors.
Mr. Economist, you were out of time, but you can take 1 minute.
Thank you, Your Honor. I'd like to just begin with the holding as the court stated it once again. The court now holds that as much as it sympathizes with plaintiffs' financial circumstances, plaintiffs must pay restitution to defendants because
Mr. Economist,
yes.
I appreciate it, and we can read it. Let me ask you, what's your best precedent in a case where, as Judge Millett was saying, the delta is 0, or as Ms. Anderson was saying in response to Judge Millett's question, the delta is 0. There was no substantive right to the money that was awarded in a judgment that was reversed.
I would turn
What's your best case that poverty matters, financial situations matter?
I would turn you to Heller versus Fortis Benefits, Your Honor, here in the DC Circuit, where there was an individual who had been receiving disability benefits. It was later shown that she had worked during the period that she received the disability benefits. Therefore, she was not entitled. And they nonetheless went into the equities and took point by point the personal circumstances of the parties. And I would like to just make one more point, if I may. I see I'm up on time.
Yes,
Thank
go
you.
ahead.
Thank you.
Go ahead.
Just that after we got off the point about whether equities are limited to the relationship between the parties, opposing counsel tried to distinguish on the basis of substantive versus procedural. But that's precisely what we see in Heller versus Fortis Benefits, also in Baltimore and Ohio Railroad Company in the United States Supreme Court. Again, I would cite to Texaco and Labuti versus United States in the Second Circuit. All of these cases hold that even in the event of a substantively overturned judgment, the equities have to be considered. That's what the district court failed to do here. And if it had taken into account the arguments plaintiffs raised, it certainly would have changed the outcome in the case. Thank you, Your Honors.
Thank you. Mr. Economist, the court appointed the Georgetown program to represent the plaintiffs here, and your briefs and oral argument have been very helpful to us. Thank you.
Thank you.
Case number 20-1190 et al. AT&T Services, Inc. Petitioner versus Federal Communications Commission and United States of America. Mr. Nectarline for the petitioner's joint issues, Mr. Reddish for the petitioner APCO, Mr. Carr for the respondents, Mr. Wright for the interveners.
Good morning. I'm John Nectarline for AT&T. The FCC had an opportunity. The FCC had an opportunity in this order to get everything right. Could have opened up the 6 gigahertz band for Wi-Fi while protecting public safety, the power grid, and other licensed uses. Specifically, as the NPRM itself proposed, the FCC could have required all unlicensed devices that share spectrum with fixed microwave links to use automated frequency coordination, also known as AFC. An effective AFC mechanism would minimize interference risks by keeping these devices from transmitting on the same frequencies as nearby microwave links. So why did the FCC ultimately choose not to require AFC for so-called low power devices? It is a mystery. You'll find nothing in this order stating that AFC would have added significant costs to these devices. Indeed, the FCC identified no drawbacks to the use of AFC, which it called simple and easy to implement and did impose for standard power devices. It's also unclear what the FCC is saying now in response to this point on appeal. Is the FCC saying that AFC is always unnecessary on the ground that even without it, none of these billion-odd devices will ever harm any of the nation's 100,000 microwave links over the coming years? Well, the FCC seems to shy away from that proposition in its brief. That's probably because the order focused on a different question, whether problematic interference scenarios are unrepresentative or atypical, as opposed to whether they're unlikely ever to occur. So is the FCC admitting now that it is likely that some of these devices will harm some microwave links, but only on occasion in unpredictable places and times? If that's the case, then the FCC had no defensible basis for ignoring calls to equip all these devices with AFC, which would avoid these.
Mr. Nectarline, I have kind of a big picture question. Could I ask you just to step back from this particular argument about frequencies? And here's my question. As I read your brief, most of your major challenges in here, the one you're now making about automated frequency control, your challenges to the Cable Lab study, to the adjustments the commission made to the AT&T study, and to all the requirements that they imposed on low power devices, things like indoor operation, contention, all that stuff. All these challenges seem to rest on your claim that the commission believed its order would eliminate all risk of harmless interference, all risk. And if that were right, I think you'd easily win, but the commission says that's not what it did. They said the order is designed to eliminate the risk of significant interference, not all interference. They say, quote, harmful interference will be a rare but possible occurrence. So if the commission's right about that, how can its order be arbitrary and capricious? Or asked another way, I didn't see anywhere in your brief where you argued that the commission's order would not, in fact, eliminate the risk of harmful interference. Do you see my point?
I think so, but let me distinguish between 3 different propositions. One is the very aggressive proposition that sometimes the order seems to be making than the government did make in its response to the stay application, but now seems to have retreated from. And that would be the argument that there is no significant risk that at any point, any of these devices will ever cause harmful interference to mission critical microwave links. If that proposition were true, then you're right. We would have a more difficult argument, but that's not what we're arguing. We're not arguing that there's a small risk that, but only an insignificant risk that at some point in time, some of these billion-odd devices will cause interference with some microwave links. We think, and we showed that it is very, very likely that at some point over the next 10 years, some of these billion-odd devices will interfere with some of the 100,000 microwave links.
Well, but
and that's what we don't know what the government's position is on that proposition.
The commission's response to that is that that's not what they were intending to do. The commission's response to this is that the order will reduce the risk of significant interference, and that if it occurs, the commission has the legal authority to stop it.
Well, what the commission said, what the commission said is very unclear. Let's assume that the commission acknowledged that sometimes over the next 10 years, there will be episodes of harmful interference, but they will be the exception rather than the rule. If that is their position, then our response to that is, well, why not impose the remedy that you called simple and easy to implement to foreclose the possibility of those harmful interference events from occurring? We also pointed out that these post hoc remedies that the commission talks about are not useful in the case of these microwave links. It's one thing in the American Radio Relay League case to say, well, if you're a dissatisfied ham radio hobbyist and you're experiencing interference from your outdoor broadband over power line system, then we can talk to the power line company about reducing that. It's very different in this context where we're talking about links that at a second-by-second basis are responsible for preserving the integrity of the power grid, for preserving communications among first responders. When one of these links goes down, the harm for that day is already done. And there will be 911 calls that won't go through. There will be failures to communicate with nuclear power reactors. That's the concern that we have here. Again, all of these concerns could be mitigated significantly by imposing this AFC requirement. Ultimately, the FCC, you will look in vain throughout the order and for that matter, throughout the government's brief to explain why didn't the FCC impose AFCs for these devices? It never said it would be too expensive. It never said it would impose delays that would make these devices unuseful for their intended purpose. Now, I expect that interveners will make arguments like that. I will disagree with them, and I'll point to places in the record where we think that's disproved. But the point is that you'll find nothing in the order where the FCC actually addresses any of those issues.
Can I ask you, Mr. Knight? Go ahead, Judge Walker.
If they addressed it in the notice of proposed rulemaking, would that make a difference?
What they proposed in the notice of proposed rulemaking was exactly what we're seeking, which is to impose an AFC requirement on all devices that operate on the same frequency bands as fixed microwave links. And so in a way, it compounds the mystery. It's not just that we proposed AFC for all devices to share spectrum.
I thought that was not in all the subbands. I thought in the notice of proposed rulemaking at JA 199, paragraph 61, FCC said something to the effect that the requirement you're suggesting would result in the manufacturing of unlicensed devices that are too complex and that are unnecessarily expensive. That's a paraphrase, not an exact quote. If they had said something to that effect, would that be enough, or would you come back?
Sorry, could you give me that JA slide again?
JA 199, paragraph 61, I think, Uh,
We believe our
Oh,
proposal.
so that's a different set of issues. What was unfeasible for there is that, remember, there are these two sets of subbands within the 6 gigahertz band generally. The subbands that I'm here talking about today, because I represent fixed microwave operators, are the subbands where the fixed microwave links operate. In this paragraph, the NPRM was referring to other subbands used by the broadcasters for mobile microwave operations. And in that context, you are correct that the FCC found that an AFC requirement would not help protect truly mobile broadcast operations, because there's no way for a database to keep track of where all these mobile transmitters and receivers are at any given moment. And that may well be true. And NAB has a separate set of arguments about what the FCC should have done for its subbands. But again, I'm here and Mr. Reddish is here to talk specifically about the subbands that the FCC was not referencing.
Can you tell me where in the NPRM they said they would apply AFC for within your bands for low power transmitters?
So the
I know they did it for standard power.
Correct. So if you
You don't have it right now, you can tell me on rebuttal. That would be easier.
I do. So what we see on JA 185, if you look at the table, the bands that AT&T and APCO and others are concerned about are the fixed service subbands. So that's rows 1 and 3 in the chart on JA 185. Those would be standard power access points. They would all have been accompanied by AFC.
But they required
The low
AFC
power
for
access.
everything that's standard power in the rule.
I beg your pardon?
They didn't require AFC for standard power devices.
In the order they did require AFC
Yes,
for standard power devices, but they did not allow these low power devices, or they would not have, if they had followed through on the NPRM, they would not have allowed these non-AFC equipped low power devices to have operated in the subbands used by fixed microwave links. That's the important point here.
Okay, I
thought correct.
I misunderstood you earlier. I thought you said they had proposed AFC for both standard and low power other than in those two bands. I misunderstood you.
No, I'm sorry. What I observed was that the FCC would have imposed AFC for any unlicensed device that shares spectrum with fixed microwave links. And that's what we're seeking here as well.
I have Judge Millett, were you going to continue on that topic?
No, I have another question, but you go ahead.
Well, why don't you go ahead? You ask your other question. I'll come back.
Well, mine's just a practical one. I'm trying to figure. You talk about. I have two questions about this. One is, you talk about, look, at some point there's going to be interference, right? They're doing their statistical thing, but at some point in your theory there is going to be interference. What is your time frame when you say that? You say it repeatedly in your brief that it's going to happen, but I never know what your time frame is, because if your time frame is yearly or monthly, that's one thing. If your time frame is every 100 years, that's a different thing.
Well, that is plainly not the time frame. The time frame is the useful life of these devices, which are coming onto the market now, and which will pose threats to these fixed microwave links for the years to come. Now, I mean, each of these devices presumably has a different estimated lifespan, but as long as these rules are in place, none of them need to use AFC, even though they're operating on the fixed microwave frequencies. And so, but
you're making your point was, look, they're dealing with statistics. We're telling you it's going to happen, right? And they aren't foreclosing. Without AFC, it's going to happen. And maybe on the low end of the statistical analyses or the low end of the bell curve, but it's going to happen. But I never got a time frame, and that could really, I should think, influence, because I don't know what the lifetime of these devices are.
So it could happen it could happen often today. And it is once these devices flood the market en masse. Now, the FCC told the court last year that it was early days in the production distribution of these devices. So the court didn't need to worry about issuing a stay until after this case had been briefed and argued. Take them at their word. But they are coming onto the market now. And what we showed, what CTIA and AT&T showed in the record, and there are full color photographs of these scenarios for everyone to consider. They were, these are real world examples, and CTI is a case essentially taken at random from the first 25 entries in the FCC's own database, showing clapboard houses of the type that you will expect to see these unlicensed devices operating in across the street from mission critical microwave.
Well, and that brings up my second question, and that is, what does it take? Is it really true that, say I lived in a house like that with a direct line to a transmission tower, and I put my router there in the window? Is that one, let's just say that one router happens to look right onto the frequency, same frequency emitting from that tower, and it's also, you know, the 911 frequency. Will one little Wi-Fi router take down 911 operations, or do we have, or would it require multiple points of access or to have actual practical interference?
Now, one device is sufficient operating at these power levels without AFC to take down a microwave link, and there's unrebutted evidence. That
one device, my little Wi-Fi router,
yes,
could have harmful
absolutely. I mean, and we're not even talking about, we don't even need to talk about aggregate interference among many different devices. What we showed was that one device is sufficient to interrupt the signals reaching a microwave receiver. It's sort of like you're in a field and someone from far away is speaking in a normal conversational voice, and you're trying very hard to listen to what they're saying, but there's someone much closer to you that starts talking loudly, and it becomes impossible for you to hear the signals that are coming to you from far away. Once that happens, the microwave link can go down. There's unrebutted evidence in the record that takes down the microwave link, not just for the split seconds of transmission that you find from these devices, but also as much as like 15 minutes while towers go down and networks need to resync. Those are 15 minutes where—
I'm not a technological person. How does it take it down? I would think there might be a burst of static, but as soon as it's stopped, why wouldn't it just keep going? It's not, nothing's physically breaking.
It's a little bit like your Wi-Fi router at home. If the power goes out, then the Wi-Fi router has to boot back up. It has to resync with the network. And that takes, that can take up to 5, 10, 15 minutes.
So Wi-Fi router
in addition,
going in and picking up on that same line takes it down, like turning the power off, as opposed to just a momentary static interference?
There is unrebutted evidence in the record that it does. Yes, it's not just momentary. It can take entire links down. The FCC never denied this. I mean, if you look at the order, we have pages and pages in the joint appendix where we make the claim that these split-second interference events can bring down networks, microwave networks, for minutes at a time. The FCC never disputed that in the order. And I mean, more importantly, your device isn't going to transmit just once. I mean, it's going to keep transmitting. It may not do it, as much as it does when you download a high def, when you stream a high def movie. But these routers are constantly communicating with other devices in the house.Ey're sending out little beacons that say, here I am. If you want to connect to Wi-Fi, this is the address you should use. Those signals that are coming sporadically but constantly from these devices can continue bringing down that microwave link across the street. And then what do? I mean, the microwave operator doesn't know exactly what's happening. You can't triangulate where this signal is coming from. It will have impaired operations for some period until somebody figures out which of the potential 10,000 devices within the vicinity of that microwave receiver is the one responsible for the interference event.
Okay. Mr. Nectarline, I have a fact question too. It relates to the 2.4 gigahertz band and your arguments on behalf of the national broadcasters. Yes. You say that that the contention-based protocol has not protected licensed users in the 2.4 gigahertz band. The commission says that the 2.4 gigahertz band rules don't require contention-based protocol. What are the facts here? Do they or don't they require? Do you know?
I'm happy to address that. I want to just frame this by pointing out that this is an issue that's specific to NAB's separate arguments. So they don't apply to protecting. Yeah. Okay.
I
So
understand.
with respect to the 2.4 gigahertz band, those devices do use contention-based protocols. My understanding is that those protocols are not required by FCC rules, but is industry
So
standard nonetheless.
the difference is that they use them, but they're not required. That's it.
Yes.
Do you know what,
I mean,
do you have any, is there anything in the record that tells us, what percentage of them use contention-based protocol?
I'm not aware of anything in the record
Okay.
on that.
All right. Thank you. That's all. Yeah, okay. Well,
Thank
I
you.
think we'll hear from, unless my colleagues have any further questions for you, Mr. Nectarline. I think we'll go ahead and hear from Mr. Reddish.
Morning. May it please the court.
Good morning.
Mark Reddish for Petitioner APCO International. The FCC changed its rules for spectrum that first responders depend upon for life safety communications. The FCC was warned, letting unlicensed devices use the same frequencies as first responders will cause interference and block emergency communications. And yet, in its order, the FCC did not address even basic public safety concerns, such as how long will it take to locate and eliminate interference? And how much harm will the public and first responders face while this is happening and emergency communications are blocked? The FCC didn't even explain why it wasn't requiring real-world testing before these new devices can flood the marketplace. There's no dispute that the FCC has an obligation to consider public safety in its rulemakings. In Mozilla, this court described the law as requiring a focused and specific study of public safety implications. That did not happen here. The FCC does not claim that it conducted a focused and specific study of public safety. And in fact,
Mr. Reddish, this whole, unlike Mozilla, this whole proceeding was about allowing other devices onto a frequency that is otherwise dedicated to safety and other sensitive forms of broadcast. The whole thing was about how do we prevent interference with those sensitive operations. And it seems like FCC said, here's how we think we can prevent it. Here's the things we've set up to prevent it. And there's a disagreement about whether they've prevented it enough or what they've proposed will prevent it sufficiently. But it's nothing like Mozilla, because the whole game here, right, I mean, diminish it by calling it a game, but the whole enterprise here was access to the bands that are already being used by public safety communications. That seems quite different to me.
Your Honor, I'd offer two considerations. First, there is a key distinction here with Mozilla in that here it's clear that we're talking about potential interference directly to first responder communications, not general internet-based communications.
Exactly.
Thus, you would think there'd be a heightened duty, more attention to public safety by the FCC. But in fact,
but that's a different argument. There's an argument that they didn't consider it. That's what was going on in Mozilla. There's a separate argument, which I now hear you saying, and that is, well, a substantive argument about their standard or their ruling, that it's not safe enough. But that's different than saying they didn't consider it. That's simply saying we disagree with where they drew the line.
Your Honor, we are arguing that the FCC failed to consider public safety. The order was only considering technical issues related to the systems used by first responders. It was not considering the public safety harms like loss of life. And when public safety is involved, lives are at stake, and those harms are irreparable. If I may, I'm sorry, I see my time's expired. Can I make one more point about foregoing the analysis here?
One more. That's it.
So this case demonstrates the dangers of foregoing the focused and specific analysis that Mozilla calls for. Essential elements of the problem are overlooked. That happened here. For example, with regard to emergency special temporary authority, this is a special provision that lets public safety agencies bypass the usual spectrum licensing rules during major events like hurricanes. We just saw this with Hurricane Ida. The FCC missed this in its order, and only after the fact, in front of this court, did it admit the omission. And counsel attempted to minimize the problem, suggesting that more than a week could go by during a disaster response without the ability to protect these specially authorized public safety communications. And that wasn't a failure to consider the public safety issues here.
We understand your argument. Thank you.
Thank you.
We'll hear from Mr. Carr for the commission.
Good morning, Judge Tatel, Your Honors. May it please the court, my name is James Carr. I represent the Federal Communications Commission. I'd like to start with the AFC point that petitioners were making. It is not correct that the commission proposed AFC for low power operations in those parts of the 6 gigahertz band where the fixed microwave links were. If you look at paragraph 73 of the Notice of Proposed Rulemaking, Joint Appendix 202, at that point, the commission was seeking comment on whether it should allow indoor low power access point operations in the bands used by the fixed microwave links. And it specifically asked whether such operation could be authorized without the use of an AFC system. It never proposed to use an AFC system with respect to those low power devices, similar to what it proposed in the other bands where the broadcast mobile operations.
Okay, so you asked for information on that question,
Yes.
and you got plenty of comments, including
Yes.
those from petitioners saying you should use them. You need to use them, you must use them, whichever verb they wanted to use. Where, can you please, this is the thing that's been bothering me from the beginning. Where in the record do you address those comments and explain why you're not requiring AFC?
I think the commission basically found that AFC was not necessary because there was no significant risk of harmful interference.
Where is that sentence in the finding that because we find no significant risk, AFC is not required? Where did you respond and then respond to their comments?
If you look at paragraph 98 of the commission's order, Joint Appendix 1299, the commission says, based on the record before us, we opened the entire 6 gigahertz band for unlicensed indoor operations without the need for AFC controlled access.
Right, that's a description of what you've done. I don't think there's any dispute that you've opened it up without AFC. Where do you answer their arguments?
And we said at paragraph 99 that there would be no AFC system, and we took 3 other steps, 3 restrictions designed to prevent harmful interference. The devices be limited to indoor operation.
Why not AFC that they say that will protect even better? Every device will protect against every device, right? You said statistically we'll knock off most of the devices. But they said AFC will protect against all devices. Where is your answer to those comments? I get you say we're not doing AFC. I get you say that, but where's your substantive response to these important comments?
Your Honor, that what the commission says in paragraphs 98 and 99 is essentially the commission's response, which is that the commission believes that even without an AFC system, there is no need for harmful interference. I would point out also this.
I'm sorry, I couldn't hear the
I'm sorry. I would point out the petitioners point to language in the NPRM that AFC would be simple and easy to implement. Well, the commission's found, even with respect to standard power access points, that AFC is not particularly simple. If you go to paragraph 42 of the order, it describes how geolocation technologies, this is Joint Appendix 1279, geolocation technologies such as GPS do not work at locations deep within buildings. And this was a problem for these standard power access points. They had to develop external sources in order to make AFC work. It was a more complicated operation for standard power operations than the commission had anticipated. It would be even more complicated if you were talking about adding this requirement with respect to mass-produced, mass-marketed, low-power access points, consumer devices.
Why is that?
Just because there are so many of them, and
why is that? I just don't know. This is my complete ignorance. Are these big bulky things you couldn't put on small devices? Are they too expensive and manufacturers couldn't just build them in? I just don't know. I don't have anything.
Fair enough, Your Honor. As the commission explains in paragraph 42, you need an external geolocation source to be connected to an access point, either a wired or wireless connection. Because if they're being used indoors, it's hard for the AFC to track them.
Yeah, no, but the whole point is when they're used outdoors.
And these are being
they're shooting outdoors.
These are being used indoors. I mean, that's the whole point. They're all being used indoors, or they're designed to be used indoors. And
But, I mean, but they say indoors can include right at the window, at which point they're going to be transmitting outside the building, right? And so this rationale wouldn't apply, or would it still apply if you're inside the building at the window? We don't know because the commission didn't say.
Well, we don't know for sure. I'm assuming that it might be easier to track if it were closer to a window. But what paragraph 42 says, if these are deep within buildings, and in many cases, as you may know from personal experience, your wireless routers are often inside your homes. So they wouldn't be easy to track.
And they're more effective next to a window.
Fair enough, Your Honor. Yes, Your Honor. Go ahead.
Were you done with that
Yes,
issue?
I'm done.
Yes.
I have a couple of technical questions.
Yes, Your Honor.
Well, first of all, okay, my router is on all the time here. My phone's on. They're in constant communication. The Cable Lab study used a data set with an average activity factor of 0.4%. Can you explain to me how that suggests to me that the communication between the two of them is occurring less than 1% of the time? Is that right?
Yes, that's right.
Can you, I mean, my phone is at this moment receiving a signal from the router, right? Isn't it?
I don't know, Your Honor, but
you don't know? If you don't know, how am I supposed to know? I mean,
I'm not an engineer, so I'm lost for much of this case. What I will say,
all right. Well, maybe Mr. Nectarline knows the answer.
I don't think I'm an engineer either.
Second question.
I wanted to point out that that figure was derived by Joint Appendix 662 is the ex parte where that data was submitted to the commission. It was taken by Broadcom from one of its customers that operates a network. And
I understand where it came from. I just don't understand it. So technologically, I just don't get it.
Well, it's the best evidence in the record, given that it involves actual real world measurements of Wi-Fi activity. And the Wi-Fi activity
in the real world where I am right now, my cell phone has been in touch with my router the entire time of this oral argument.
I tell you, teenagers in the house, they got 15 devices going.
Yeah, see, I don't even have any teenagers like Judge Millett.
There is a phone,
right.
There is a watch, there is an iPad, there's a wireless laptop.
Okay, so next technical question. I asked Mr. Nectarline about contention-based protocol in the 2.4 gigahertz band. And so do now I understand it that it's not required, but many of them used it, right?
That's my understanding, yes.
Is that your understanding? Well, the reason I asked the question is their claim is that there's been chaos in the 2.4 gigahertz band from which the commission has been unable to protect them. Your answer is, well,
I'm sorry.
Can I finish my question?
Yes.
Let me just finish. Your answer is, well, now we're going to have contention-based protocol, but according to you and Mr. Nectarline, both agree that contention-based protocol is used in the 2.4 gigahertz band. So if this contention-based protocol operating in the 2.4 gigahertz band, how does that give you any assurance that it will be better here in the current one, the new one?
Let me observe.
Do you see my point?
I do see your point, Your Honor. The only evidence of what you described as chaos in the 2.4 gigahertz band is there's some anecdotal evidence. There's one example given of some interference in the Phoenix area of mobile broadcast operations where the program coordinator, which is not affiliated with the FCC, it's a private coordinator, frequency coordinator, identified the source of the interference and told the people operating the devices to stop using them. But at least according to the record, those device users turned on their devices again and created the same sort of interference. My impression from, I'm sorry.
Where did the commission respond to it? Okay, I overstated chaos. I understand that. But where did the commission respond to the national broadcasters claim that the commission has been unable to protect them in the 2.4 gigahertz band?
Well, that was one isolated case they identified in the record. And as best I can tell from this description in the record, neither the commission nor its enforcement bureau was involved. Because typically what would happen if the enforcement bureau were involved, it would notify the users of the interfering devices to turn them off. And it would also send them a notification, a letter saying that the devices should stay off until the harmful interference is resolved. And there's a description of how that works in at paragraph 397, or I'm sorry, footnote 397, Joint Appendix 1320, the commission cites a notification of harmful interference to Victor Rosario of Brooklyn, New York. And in that notice, basically the commission told Mr. Rosario, we see that you were operating a device that is causing harmful interference. We told you to stop. We want to confirm that that the device is still off, and if you turn it on again and it continues to emit harmful interference, you could be subject to monetary forfeitures under Section 503 of the Communications Act and other enforcement measures, including so much as, in extreme cases under Section 510 of the Communications Act, the offending device could be seized. So I think if the commission had been involved in that, if the broadcasters had invoked the commission had summoned the commission's enforcement bureau, that problem would have been resolved.
All right, my last technical question is, the petitioners say that these low power devices that have content-based protocol, that they only detect each other. They don't protect point-to-point beams transmitted by microwave towers.
Yes.
And if they're right about that, then this contention-based protocol won't help them, right? Because, say you live in a building with you live in an apartment building and there's half a dozen routers, and the routers are all sensing each other and only coming on. Well, that means a router is going to be on all the time. And they say that's the problem, and these contention-based protocols won't detect the point-to-point transmissions that they fear, that they worry about from microwave towers. What is the answer to that?
Let me say, first of all, that contrary to, petitioners have suggested that these unlicensed devices will never be able to detect the fixed microwave transmissions. And what the commission said in footnote 374, JA 1317, is that indoor unlicensed devices may not always be able to detect the presence of microwave signals. The FCC's engineers believe that in a number of instances, these will be detected. But regardless of that, Your Honor,
but isn't it pretty important to know? Isn't it pretty important to know how significant they may not always have the time?
The primary reason the commission adopted the contention-based protocol was to limit the amount of time that these unlicensed devices would be transmitting, so that no one would be transmitting continuously with a strong signal.
But Mr. Carnal, in an apartment building where you have a couple of these or many of them, maybe I'm misunderstanding this, but doesn't it mean that at least one will be transmitting all the time? I mean, at least one, not the same one.
Well,
One of them will
different
be on
ones,
all the time.
well, different ones would be transmitting, but again, if it is one particular device that is problematic as opposed to another, then the problematic device would only be on for a short period of time. Part of the problem with this analysis is that it's particularly complicated in terms of there are so many different things that protect against harmful interference in this context. And the commission talked about them. There's building loss, there is clutter loss, there is the low activity factor, the fact that these devices aren't on all the time. There is the probability of co-channel occupancy. The only way these devices are going to interfere is if they happen to occupy the same channel. And as the commission pointed out in Table 6, Joint Appendix 1313, in many cases, there's less than a 10% chance of co-channel interference or co-channel occupancy. Another thing to keep in mind, particularly important, is the strength of the signals. Normally, and this goes to what Judge Millett was asking about, can one device knock these things out? In the worst case, it could, but normally, normal circumstances, the transmission from a fixed microwave link is so powerful that even in their worst case, the transmission from a low power access point is not going to be strong enough to cause what we know as harmful interference. That is to.
And where does it say
Where
that? Where in the order does it say that?
And that's at paragraph 143, where the commission discusses the phenomenon of deep atmospheric multipath fading. That's a meteorologic phenomenon. The commission says, J 1317, paragraph 143, potential degradation of a microwave link will only occur if a deep atmospheric multipath fade occurs at the same time the microwave receiver receives.
I apologize. I think I'm at the right page. You said page 1313?
1317, my apologies.
17, that's my, I was looking at the wrong paragraph.
Before you read it again, explain to me why that's relevant to the question we're talking about. Why is a deep, what did you call it? Deep atmospheric what?
Atmospheric multipath fade.
Okay, why is that comparable to a low power router?
Well, what a deep atmospheric multipath fade does is it's a disturbance in the atmosphere that causes the received signal from a fixed microwave link to lose power. It causes it to weaken, the signal to weaken to the point where you can have degradation, you can have harmful interference from these low power devices. But without that fade, these devices, these indoor low power Wi-Fi access points are not going to, as long as they occur outside the fade. And the commission explained in paragraph 143 that these fading events don't occur often. And they typically occur between midnight and 8 a.m., which is outside the peak usage period for these Wi-Fi access points.
Okay. We've taken you well over your time, and let's. Oh, go ahead, Judge Walker.
I do have one.
Oh, go
please,
ahead.
Judge Millett.
Judge Walker, you go.
Yeah, go ahead.
It's one question, but it is rather long, Mr. Carr. Just as a heads up, it seems that in 3 ways the FCC may have acted arbitrarily and capriciously. It seems like perhaps with regard to mobile microwave signals, you said that with the pre-existing bans, there had been no problem, but you didn't cite any evidence to support your assertion. With regard to the AFC for the 6 gigahertz that we talked a lot about, it seems you described what you were doing instead of AFC, but you didn't say why AFC was not a better alternative And this is very in the weeds, but there was a CII study that led to a letter from Edison in April, which was kind of a follow-up letter, and there was no response to that letter. There was a kind of a footnote that you dropped, but the footnote just said what you had said before the letter. Now, if I'm wrong on any of those, I'm sure you think I am, tell me why. But after that, tell me, even if I'm right, why we should remand without vacating.
Okay. Let's start with the third scenario first. You were talking about the CII study, Your Honor. That April letter that they cited, and I think the commission explained this in its brief, that April letter largely relied on a March analysis prior to the commission's order being released. And the commission addressed all of the relevant points that had been raised earlier. The fact that go ahead, Your Honor.
No. We're very late. I'd rather just listen.
Okay. Okay. With respect to your first point about not citing any evidence of no problems with interference in the 2.4 gigahertz and 5 gigahertz bands, I would say, I mean, it's hard for the commission to prove a negative there. I mean, essentially, none of the parties have produced any evidence, with the exception of that one isolated incident in the 2.4 gigahertz band from outdoor operations in the Phoenix area. So it seems to me those are examples where there are a multitude of devices in those being used in those bands, and only isolated instances of harmful interference that have been effectively identified and addressed by the commission. I'm trying to recall your second point. Your second point was...
It was you described what you were doing instead of AFC for 6 gigahertz, but you didn't say why those were better than the alternative AFC.
I've indicated in my responses earlier to Judge Millett that I mean the commission just basically said AFC wasn't necessary because there was an insignificant risk of harmful interference here. Again, I would say, and I'm sorry, and
go ahead. Finish.
You had one final question about
why we should remand without vacating. If,
well, of course,
I know you don't agree with me.
I don't think you should remand at all.
If we conclude on those three, if why are those three things not enough to require vacating?
Well, as I've already explained, two of them.
Assume I disagree.
Responses on the AFC.
This is a somewhat Mr. Carr. This is a somewhat friendly question. Assume that I disagree with you.
Yes.
But I think that this is an instance where we shouldn't throw the whole order out.
Well, I see where you're coming from, Your Honor, and I appreciate.
We should just remand so that you can clarify some things that you should have addressed before. Tell me why that's what we should do.
I think if the court is going to remand, that remand without vacater would be appropriate here, because vacating this order would be incredibly disruptive, given the fact that devices have already started to be deployed, and also I think to the extent the commission is, or the court is looking for further explanation from the commission, I think it's well within the commission's power to provide that explanation, if in fact the court feels that further explanation is needed.
Okay, thank you very much.
I just had one more question.
Yes, Your Honor.
And this again is just sort of a factual point me in the record. The Cable Lab study relied on a test of, I think, 500,000 with devices in New York City.
Yes, Your Honor.
Which I would submit and maybe take judicial notice of as an area with enormous building and external clutter, probably amongst the highest in the United States. On what basis, give me the explanation and point to me in the record, did the commission conclude that that was remotely representative of the risk of interference nationwide in dramatically different environments?
Well, I think, Your Honor, I understand your point. I think the commission's view was that these access points were distributed throughout New York City. Now, there are certainly portions of New York City that are filled with buildings and clutter, as you put it. There are other parts that are more remote from the downtown and the Broadway area that are not
New York City itself, there's areas that you would say don't have, maybe not as intense. There may be degrees of intensity, but my question again is how it's representative of the entire United States from someone who grew up in the Midwest.
I grew up in the Midwest too, so I think the commission's point.
Did they not address that issue? Is that why I'm not asking you to answer it. I'm asking you to tell me what they said and where.
I don't think they really said anything directly about that. I think the commission said given this probabilistic analysis, this was the best evidence the commission had in the record on the subject of the likelihood.
Okay, so if an agency has a really, really important question to decide and 20 studies are submitted, all of which have flaws, none of which have statistical significance or involve representative conditions for the nationwide type of determination the FCC has to make. Is it reasonable or is it arbitrary and capricious for the agency to say, well, this is the least worst of them all, and I'm going to rely and make all kinds of projections based on that? Or should the agency say, we're the experts? We're going to either request better tests or do them ourselves.
Well,
First of
normally,
all,
Your Honor,
least worst seems a bad way to decide things.
Normally, Your Honor, the commission doesn't conduct its own studies. It relies on the parties. I mean, I suppose what it could have done is it could have asked the parties for more evidence, but there were hundreds of studies submitted.
Were any of them more representative than just New York City?
And some of the studies, and the commission cited a couple in footnote 373 at JA 1317, Monte Carlo studies that assumed a large number of devices transmitting in the 6 gigahertz band and over a large region. ECC report 302 was focused on the entire European Union, and the RKF report assumed 1 billion devices in its analysis of deployments throughout the United States. So,
and they were consistent with the cable
and
labs?
those right, and they reached conclusions consistent with cable labs that there was no significant risk of harmful interference.
Thank you.
Okay, thank you. We'll hear from the interveners here.
Thank you, Your Honor.
Mr. Wright.
Thank you, Your Honor. And Christopher Wright, representing the interveners supported in the FCC. I'd like to start with the discussion of AFC. In paragraph 147 of the Commission's order, it directly recognizes the claims of AT&T and CTIA and others that there ought to be an AFC requirement.
What page? Where are you?
Paragraph 147, which is JA 1319. By the time you get to paragraph 147, the Commission has, of course, said that it concludes that there's no significant chance of harmful interference a number of times. Now you have to skip over paragraph 148 where it starts, we also disagree with another contention of CTIA. And then the first sentence of paragraph 149 says, we disagree with AT&T and CTIA's views about the likelihood of harmful interference. So as Mr. Carr said, it's very clear from this order that the Commission did not adopt an AFC requirement because it thought there was an insignificant chance of harmful interference without one. And that's the issue before this court. And
is there a number on insignificant risk? Insignificant risk could be 20%, 10%, 30%. Is there a number somewhere? Because when you're talking about health and safety, one would,
Yeah,
No,
no,
I want a much lower percentage of
right.
insignificant.
Well, the commission hasn't given numbers, and realistically, I don't think that's possible. It's defined harmful interference to require serious degradation, repeated interruption, obstruction, or endangerment.
Well, obstruction doesn't have an adjective with it, so, or an adverbial adjective with it.
Right. Well, you know, this requires obviously more than interference and regular interruptions and that sort of thing. I think the commission is right in saying that it can identify harmful interference, and it didn't just throw up its hands and say, you know, the Cable Labs study is the least worst study. It took a very careful look at all of these studies and concluded that they show that there's an insignificant chance of harmful interference. You know, with respect to the Cable Labs study, I think the most important thing is that the commission has made clear that it thinks these worst case analyses aren't worth much, that a risk-based analysis is much more sophisticated, and yet AT&T just came in with worst case analyses. So
Why aren't they though? Just help me understand, because they sound pretty awful, right? If all some bad actor has to do is start take Wi-Fi's outside, routers outside, and start pointing them at a tower to disrupt 911, that's rather disconcerting. And even if it's only going to work 25 or 20% of the time, that seems
Your Honor,
a lot for safety.
The evidence from my friend, Mr. Nectarline's client, isn't even anecdotal. It's not even mostly something that happened. It's sort of, we can sit here and think of a combination of 12 things that are all unlikely, but yes, it's possible they could all happen at once. And the FCC's engineers are quite sophisticated, and they start actually, I believe, with your intuition that your little router is unlikely to bring down some powerful fixed wireless device, but it is technically possible if a whole lot of things happen at once. One of the things that happen, that has to happen, is this deep fading event that Mr. Carr talked about, that's discussed in paragraph 143. And I want to highlight that even though the commission, you know, said quite clearly that harmful interference will only occur if there is both an excessively high power transmission from an unlicensed device and a, quote, deep atmospheric multipath fade, unquote. And the other side has just completely ignored that paragraph. They didn't mention it, so we didn't. We mentioned it just to make that clear, and in their reply, they just ignored it again. So, I mean, I think the petitions can be dismissed, you know, for that reason alone. The commission said that it thinks harmful interference will only occur if there's one of these deep fading events, and you know, we've got nothing from the other side on that.
Can I also ask you about the 0.4% activity factor? This must come from my ignorance, because like Judge Tatel, I swear my kids are burning out the Wi-Fi every time they're awake, every hour they're awake.
Here's how I understand it. It's like when you download a video, the video then is on for 2 hours, but it downloads in a burst. And you know, with the new wide channels in the 6 gigahertz band, it's gonna download in a really tiny burst. So you might be watching for 2 hours, but the connections were a matter of seconds or less.
Yeah,
Okay, so does that mean that, let me just ask, because is that the answer to my question though? So the router is always sending out signal, correct? But that's not the signal that anybody's worried about. The signal that they're worried about is the time when the router is not just sending out its signal, but it's when it's communicating a message. Is that right? Or do I not understand that?
Right, well, let me try this way. I mean, it's not just because the light is blinking or something like that. That doesn't mean you talk, but your communications, your voice takes up so little bandwidth.
No, but isn't there a signal right now coming from my router to my phone?
Probably not, or it probably takes, you know, a
My
split second.
my phone says I'm connected to my router. How does it know that unless it's receiving a signal from the router?
But again, your TV is connected to something too, and you're watching the video, but the burst has
Mr. Wright,
occurred and has.
Can I ask if this is how it works? Let's say that every 5 seconds the router sends something to my phone, but it only takes it 1/100th of a second to send it. So that would mean we're looking at
that's essentially my understanding.
1/500th of the time. I'm just making those numbers up completely, but that could get you to a number like 0.4%.
Yeah, zero, right. And well, let me point out that while the petitioners have what I think of as a grumpy footnote in their reply brief that sort of says we don't really believe this. You know, they're capable. This is AT&T and a lot of other big companies. They could do their own study. If there was some reason to doubt the 0.4%, they could have put it in the record and they didn't.
Okay.
Can I ask him? Go ahead, Judge Tatel.
No, you go ahead. I was gonna.
I just had a question.
Keep going.
About enforcement, and that is, you know, John was talking about Phoenix, but that was different types of communications altogether. And the whole premise here is that just a legion amount of new devices and Wi-Fi devices are going to pour into the market, into the households, everything from, you know, toasters to doorbells to the stuff we're talking about now, phones and televisions and computers. How is enforcement possibly going to work if there actually is some interference that happens? How is it possible? You're never going to be able to figure out who, I mean, I guess they can't even come to the curtilage. They have to walk around the block looking for Wi-Fi routers and windows, or I just don't know how people can move it outside and then move it back inside. I don't understand how enforcement works here. I really don't.
So again, you have to have this confluence of events. But you know, petitioners nicely put some pictures in their brief of places where they thought sort of interference might occur. And, you know, it won't take deep study to figure out, geez, we should look in that flimsy shed there. Or is there somebody on the patio after midnight for some reason? And again, it's
well, by the time, you know what, by the time the investigators get there, unless you tell me they're just roving around shining flashlights in people's windows looking for routers, I just don't understand how it's going to work really in the way that
it's going to be a router police, Patty.
Right.
Well, you know, the FCC has experience tracking down pirate radio stations, and of course they're trying to hide from the FCC. So somebody who goes out after midnight, you know, and takes their router outside, because that's the thing that would cause the interference, not just a laptop. And you know, they're not even hiding. So
unless we're way over, unless you have more questions.
No.
Did you? Okay, great. Thank you. Thank you, Mr. Wright. Let's see. Mr. Nectarline, you were out of time, but you can take 2 minutes.
Thank you. First, I want to respond to the point that they didn't impose AFC because they found there was an insignificant risk of something. Focus on what the something is. They said there was no significant risk of. What they were ultimately saying is, in the mine run of normal cases, there is an insignificant risk that a given router will cause a particular microwave link to go down. The FCC was always focused on that question, not on the one we're concerned about, which is whether over time, in the trillions of interactions between these billion-odd devices, 100,000 microwave links, whether it is likely, and as indeed it is, that some of these microwave links will be compromised. Number two, AFC is not particularly difficult to implement. The FCC is implementing it right now with respect to standard power devices. There are well-accepted protocols for consumers to take their devices to Windows or to enter their addresses. Those will go 99% of the way towards resolving concerns of the type that we're here today to discuss. Again, the FCC never explained why it didn't impose the AFC requirement for these devices, even though it proposed in the NPRM, again, to use AFC for any device that shares spectrum with these microwave links. Deep atmospheric fade. I'm glad that Mr. Bright brought that up. He faults us for not addressing it in our reply brief. Well, the FCC didn't address deep atmospheric fade in its own brief, and that's why we didn't feel the need to address it. And it's for good reason the FCC didn't address it. It's because these fade events happen constantly. To be sure, they can be particularly bad between midnight and 8 a.m., but there was undisputed evidence in the record that they can happen any time of day. They can happen in very problematic ways in the morning if there's fog. It can happen at 10 a.m. at night. AT&T submitted evidence to that effect. The FCC never responded to that. And I would like to refer you to JA 611 and 612, 644 to 647, 1236 to 37. I see my time is out. I had a couple of additional points.
I'm sorry, could you just say those page numbers again?
Sorry. Okay. So the, I'm sorry, so the JA, yes. So if you look at
just give me the numbers.
1237.
Mm-hmm.
Also, AT&T submitted an ex parte on this whole issue of fade that is not in the joint appendix, but it's available on the FCC's website and is part of the administrative record, is an AT&T ex parte letter dated August 8th, 2019. Also, APCO addressed this issue in its comments, JA 375, where it talked about fade events in the morning. The point is that these microwave links are precisely engineered, not just to blast a lot of power at receivers, because these microwave links have to avoid interference with one another, and the FCC has to regulate their power. They are precisely engineered to cope with constant threats of environmental degradation in the form of shifting atmospheric events. They are not engineered to cope with additional man-made interference on top of that. And that is a point that the FCC never adequately addressed in the order as well. And again, I just want to close by pointing out that all of these issues can be addressed through AFC. AFC is the solution to making sure that these mission critical microwave links don't fail. I see my time is out. I do have a.
Yep, no, unless my colleagues have any other questions, you're well over time. Thank you.
Okay, thank you very much.
Yeah, gentlemen, thank you all for your arguments today. The case is submitted.
This honorable court is now adjourned until Monday, September 20th at 9:30 a.m.